April 30th, 1977. This is my date of nativity. Yeah.
And your current mailing address?
My mail receivership is 22 Thomas Street, Holly, New York, 14470.
All right. The name that I have is a different last name. Can you please repeat the name that you prefer to go by?
Layman.
All right, that is the name that I have. My apologies. All right, I'm going to place you on a brief hold. When I take you off hold, you'll be on speakerphone with the court, and the matter will begin.
Excellent, thank you.
Thank you.
hear me?
I can hear you.
All right, we're on the record, and we're going to be proceeding now. All right, there are several matters before this court. First, we have the matter of should be entitled the Department of Social Services on behalf of Jolene Lehman against John Lehman. This is docket F-03050-14/148. This is a petition of non-consent filed by John Lehman. Next matter for the court is under the matter of Jolene Lehman against John Lehman, docket F-03050-14/23H. This is entitled a petition for declaratory judgment and constructive notice. This is filed by John Lehman. The next is also filed under Jolene Lehman against John Lehman. This is under docket F-03050-14/23H. This is a writ of habeas corpus filed by John Lehman. Next, also under docket F-03050-14/23H is a request for records in advance of hearing. This too has been filed by John Lehman. Finally, we have filed under the same docket F-03050-14/23H. This is entitled a petition for relief. The court has also received an affirmation in opposition to petitioner's motion. This was filed by attorney Robert Figliola, counsel to the Commissioner of Social Services. We have appearing on the telephone John Lehman. He appears apparently without counsel. Sir, you have a right to be represented by a lawyer. You may hire one at your own expense, or you may represent yourself throughout these proceedings. If you wish an adjournment to seek or to consult with counsel, you may ask for such an adjournment. How would you like to proceed, sir?
I am proceeding as John Kelvin Seth Lehman in special appearance on behalf of my estate, John Kelvin Seth Lehman, as the agent and executor.
Do you wish an adjournment so you can seek counsel?
No adjournment is sought.
Right. We have appearing in the courtroom Jolene Lehman, who appears without counsel. Ma'am, you too have a right to be represented by a lawyer. You may hire one at your own expense, or you may represent yourself throughout these proceedings. You as well have the right to ask the court for an adjournment to consult with and possibly hire counsel of your own choosing. How would you like to proceed? So, also appearing in the courtroom is attorney Robert Figliola, counsel to the Commissioner of Social Services. So, Lehman, these are your motions. You may go first.
Prior to us proceeding, first of all, I would like to say thank you to the court and thank you, Magistrate Weinsack, for hearing this case and the matters before this arbitral tribunal. First, I would like to thank you for convening the session today. I acknowledge your position and the responsibilities that are entrusted to you in this matter. My intent is to address concerns about jurisdiction, procedural integrity, and to ensure the process is aligned with the principles of fairness and equity. As a preliminary matter, I respectfully request that the tribunal clearly define and address the following issues before the proceeding any further, which is a jurisdictional basis. It is imperative to clarify in specific jurisdiction under which these proceedings are being conducted. Specifically, I challenge any implied or asserted reliance in rem or in personam jurisdiction, as it as it is invoked in maritime and admiralty time law. This case pertains to a domestic matter and does not involve maritime commerce or any actions governed by admiralty time jurisdiction. Therefore, I respectfully assert that such jurisdiction, if invoked, is improper and inconsistent with the facts and the nature of this case. Second, the seat and the venue of this arbitration, to ensure transparency and avoid ambiguity, I request that this tribunal formally declare seat and venue of this arbitration proceeding. Doing so is essential to establish a legal framework governing this proceeding and applicable to procedural rules. Failure to define the seat and venue raises concerns about jurisdictional overreach and procedural fairness, potentially prejudicing my ability to defend myself against the claims of the county and the claims of Jolene Lehman, who has assigned her rights to Erie County. Nature of claims as a commercial contract is the third item that needs to be addressed. It appears that these proceedings seek to enforce claims that function as commercial contracts, potentially involving contracts of adhesion. I respectfully assert that any such contracts must be supported by the following documentation: a financing statement and a notice of assignment from Jolene to Erie County Department of Social Services, and then subsequently to Conduit State and Local Solutions, which would be in compliance with New York State's use of the Uniform Commercial Code. Evidence of an agreement or consent, which I have not provided in this matter. And without these, I contend that the claims that have been brought before the court on the other party have no standing. And these issues need to be addressed before we continue any further. And with Jolene being there present in the courtroom, she has assigned, as an assignor, her rights to Erie County Department of Social Services. She is not consented to be in the room. I'm asking her to leave the room because she already has representation from Erie County Department of Social Services.
Sir, the courtroom is a public courtroom, number one. Number two is Ms. Lehman is the custodial parent. Is that correct, ma'am? Yes. Your request to have her excluded from the courtroom is denied. Anything further, sir?
On what grounds? She's an assignor to a contract.
Mr. Figliola, is Ms. Lehman an assigner?
No, Your Honor. This is not a public investigation. All you're required to do in this matter are
That's not what the paperwork states.
Anything further, sir?
Before we move any further, these claims that I brought before you need to be addressed. I do not consent to go any further until you address jurisdiction, the seat and venue of this arbitration hearing, and the nature of claims as a commercial contract, which are hereby assigned to Conduit State and Local Solutions, which is a private corporation that is in holding, in freehold of matters of my estate. Please address these issues.
Sir, you have filed motions with the court. I'm giving you an opportunity to make argument on these various petitions and or motions that you have filed. Is there anything else that you'd like to tell the court before the court hears from Attorney Figliola in his response?
With the accord and satisfaction that has been placed in the court, which you haven't cited as a record that has been put on the record, even though the record states that it's in there, is a motion that was placed in yesterday that specifically shows that there was an accord and satisfaction and that the account has been closed out through Bank of America using UCC 3-311 as an accord and satisfaction and a draft note. Conduit State and Local Solutions accepted for value that note upon special deposit, and it was deposited upon Bank of America account in agreement to close the account. That has been recorded as a UCC on record for New York State and also with Orleans County. Erie County has received receipt, both Erie County Department of Social Services and Erie County OCSE, which is a subsidiary of Conduit State and Local Solutions. They have many different names, but that's the primary moving vehicle in Erie County. They've received notice of this accord and satisfaction along with a 1099 OID. So all the principles and equity, the account has been closed. Are you still?
Sir, this is your day in court.
Before we go any further, please address the issues of jurisdiction, Mr. Weinsek.
Sir, this is your opportunity to make argument to the court on these petitions.
I am making argument right now.
And at the end, if I find it to be appropriate. Is there anything else, sir, that you'd like to tell the court with regard to any of these pleadings you have filed with the court?
Before we proceed any further, we have to address the issues of jurisdiction, Your Honor. It's simple as that. You have to establish jurisdiction and you have to establish the seat and venue to ensure that there are fair dealings in proceedings. This has not been done. It hasn't been done in a commercial aspect. It hasn't been done in a judicial aspect. I'm asking respectfully that you address these issues prior to us proceeding any further.
Sir, are there any other issues that you'd like to raise here with the court?
Your Honor, I need for you to address the issues of the maritime law and admiralty law jurisdiction. And I need you to address the seat and venue of the arbitration and the nature of the commercial claims that are being brought against me via third-party contract that is held by Conduit State and Local Solutions, to include the financing statement and the contract agreement. This must be addressed prior to us moving any further, Your Honor. I'm asking respectfully.
And how, sir, or why should it be addressed before you've completed your argument?
Because when jurisdiction is challenged, jurisdiction must be answered. You have to have defined a jurisdiction. If you have jurisdiction, then you would easily state that you have jurisdiction and on what grounds you have jurisdiction. The jurisdiction has been challenged of this arbitral tribunal for the reason of applying maritime and admiralty law as it applies to commercial contracts. I see that it doesn't look like you're ceding any information dealing with this, so you concur that you are using admiralty law and maritime jurisdiction currently.
That's not what the court has said at all. I'm giving you this opportunity to make
So,
argument
What is the court saying?
Conclusion of this, the court will render a decision if I find it to be appropriate. You may certainly argue to the court this court lacks jurisdiction, and then you may continue if you have additional arguments that are in the alternative.
The argument is that this court doesn't have in rem or in personam jurisdiction and is invoking maritime and admiralty time law as it applies to commercial contracts, which does not apply to arbitrational settings dealing with state courts. That rests upon an Article 3 court, which is a federal district, not state venue, as it applies to this contract. And as far as the seat and venue, that issue still hasn't been defined. So the tribunal is equally not giving footing to either the seat or the venue to properly establish a framework, a legal framework, in which the parties can establish claims or give defense or give offense claims. So there's no information. We're in nebulous zone right here. There's nothing to be defined. And in law's just that. It's definitions. What is defined by a definition? To know something is to know its name. And this court has not defined anything that deals with jurisdiction or with seat and venue, particularly dealing with the arbitrations that we are going through. And the nature of the commercial claims and the commercial contracts, when the commercial contract was initially brought into this arbitration setting, I was never given a rebuttable presumption from Erie County Department of Social Services on behalf of Jolene Roxanne Lehman. That never happened. So 45 USC, I was never given a rebuttable presumption for me to give defense. So this is essentially like shooting ducks in a barrel. If you don't give somebody a rebuttable presumption, then the procedure in law is flawed. You know, the issue with not receiving proper notice of assignments or financing statements dealing with a specific contract, or receiving a contract that has specific performance that is applied on both sides. Now, if we go back to the original contract, which is the judgment of divorce, there's specific compliance that has not taken place on Jolene Roxanne Lehman's behalf. She was in an automotive accident in 2018, and this is after the facts were stipulated in the judgment of divorce, that she had to remove my name off of the vehicle and assume all the duties and responsibilities it would take with owning that automobile. She didn't do that. She struck a pedestrian and blamed it on me. She blamed it on my estate, which that's not fair, that's not equitable, and that definitely doesn't go to specific performance. So with this being stated, there's the contract of adhesion that was based on consent, which was construed off the words, "Do you understand?" And that doesn't mean that I had the proper assent to a contract to give consent to a contract. That was running off of presumption and assumption that things could be construed or interpreted as being contractually binding. I don't consent to contract with Department of Social Services or contract with Jolene. Jolene has proven time and time again that she cannot adhere to contracts. That's why she's claimed bankruptcy. That's why she has rolled in credit cards and all this to a bankruptcy because she can't keep commitment. She can't keep her word. And with this being said, this arbitral tribunal doesn't have in rem or in personam jurisdiction, nor does it have jurisdiction as maritime or admiralty time law. Counsel stated that this has nothing to do with admiralty time law, and I placed upon the record yesterday that it in fact does, because SIMLA and FIMLA are applied to contracts that go through OTDA and the DTF, dealing specifically with the DMV and application to motor vehicle transportation. That was placed in the record yesterday. So that statement is felonious. That was put on the record by Mr. Figueroa. Have you had a chance to read the records that were placed in the file yesterday, Your Honor?
Sir, you've made a lot of filings with the court. I've been trying to keep up with all your filings. Is there any specific document that you want the court to review right now?
Give me one moment. Yes, the notice of bias and unfair dealings with exhibits. That is correct.
Okay. So I have it in front of me. Sir, you may continue.
There needs to be a distinct difference between me as the man and John Kelvin Seth Lehman, the estate. They are two separate entities. I am the living man, and I can act on behalf of the estate of John Kelvin Seth Lehman. The estate has been held under trust by the arbitral tribunal for an arbitrational award for Jolene, and it's simply an unjust enrichment. I am not an infant or a decedent. I am a man, and at common law, I have rights. So you're not dealing with a dead entity or an infant or somebody that's incompetent to be lost, missing, abandoned, nor have I given up custodianship of the record for Forrest Isaiah Seth Lehman. The original record rests in my possession. to include his estate and a trust. And at this point, I'm operating under trust that has been registered at Orleans County. If you go to page 17, Your Honor, there is a letter from the court refusal filing of motion de novo. I never received the motion de novo back. It was taken.
Wait, you said page 17?
Yes, this is an 84-page document.
Right, let me just give me one moment to get there. Page 17 that I have is Exhibit E, letter from court clerk that refused filing of a motion de novo. Is that what you're referencing, sir?
Correct. The motion de novo was never handed back to me. It was taken, but I never received the motion de novo back. That's why that record is not in this claim, because I never received the record that I handed into the tribunal at that time. If you continue on into the record, you will see that an accord and satisfaction has taken place, and with the back of the draft note that was given to Conduit State and Local Solutions, it was deposited, and on the back of that deposit of the draft note, if you look at the top of the draft note, it will say Bank of America in very tiny writing, and then it's by
What page, sir, are you referencing?
37, page 37.
You may continue, sir.
The draft note on the back of it says, by acknowledgement and endorsement of this draft note, the payee acknowledges the full and final settlement of all sums owed to the payee by payor on accounts of SF 2010 903055 and subsequent modifications. Remit all payments back to payor upon termination of trust agreement per grantor, trustor request. That was time-stamped by Bank of America on behalf of Conduit State and Local Solutions, who is the vendor of services for Erie County DSS. If you go to the next 2 pages, you will see a UCC, which is basically a screenshot from New York State's debtor classification, stating that I am not a debtor by New York State, nor any of the counties in New York. This goes by the mailbox rule, and this is covered by the UCC 3-10 or 410 acceptance of drafts, 3-303 value and consideration, 3-302 holder in due course. The continuation goes on to show that TransUnion gave feedback to the closure of the account, along with the Consumer Finance Protection Bureau complaint that was made upon Bank of America for this account in particular, and the feedback from TransUnion that is given. A follow-on to that is audio from the Department of Taxation and Finance, which is the Civil Enforcement Division, Child Support Division. There's audio on there. The audio's roughly an hour and a half long, but I've transcribed that via using Google's collaboratory whisper model AI. And if you go on and you read this material, page 44 to, or forgive me, I'm going to give you the exact pages. So from page 40 to,
Sir, you're breaking up.
page 40 to 51 is confirmation that no account that is file number 197206 or CSMS account BV15080G1 exists in New York State's child support system, and I asked for that person at the DTF to look into Erie County, and they also confirmed that there's no account or case at Erie County. A continuation of that is New York State Department of Taxation and Finance Civil Enforcement Division records request and response, which shows that there are no accounts that are receivable for New York State. And also, there is no power of attorney. New York State Department of Taxation power of attorney. No general power of attorney exists for my estate. And that goes for Erie County as well. Nobody in Erie County has expressed or has been given expressed consent by me to be a representative of my estate. Exhibit L, which is on page 56, is IRS Form 1099 OID, which was provided to Erie County Department of Social Services and New York State Department of Taxation and Finance. They have received records of this filing along with UCC filings that are UCC1, UCC1AD, and UCC5, demonstrating that these accounts have been administratively closed upon agreement from Conduit State and Local Solutions on behalf of their represented party, which is the Erie County Department of Social Services. Then Exhibit M goes on to IRC Section 468 or 468B, corporate entities, short-term treasury bills, CRIS investment tool system, is stating that this tribunal and subsequent tribunals per the Department of Taxation and Finance are privatized corporations. Exhibit N are the commercial practices and federal regulations that align with court operations and fund management as follows. UCC Article 3 and 8, negotiable instruments and securities aligned with treasury bills under CRIS. 31 CFR Part 202, depositories holding funds as financial agents, similar to the CRIS operations. 26 CFR Section 1.468B1, qualified settlement funds taxed like corporate entities. 31 CFR Part 356, Treasury Security Auction Process for Investment, and then Title 12 CFR Banking Regulations for Custodianship. 26 USC Section 4371, excise tax mechanisms applied to financial instruments. In this, you will see the administrative directives that are handed down from OTDA to all the commissioners of Department of Social Services, to include the Department of Social Services at Erie County, which is 0580M 04, which goes on to explain that these are in fact excise taxes that are being put upon a estate.
So, sir, just not to interrupt, but you're saying that if I look at the ADM, it talks about excise taxes being placed on an estate?
It can be construed that this is excise taxes on an estate as it applies to commercial contracts.
So, but I want to, before you said it can be, I'm not sure what can be construed as an excise tax.
An arbitrational award can be construed as an excise tax in commercial.
And is that in this ADM? Where is that in this ADM, sir?
In that ADM, in combination with Exhibit M, which explains the CRIS registry system, which is the Court Registry Investment System. And the articles and the CFRs in combination with that ADM, one could logically deduce that these are excise taxes that are being applied under SIMLA and FIMLA under the guise that it's an arbitrational award.
Continue, sir.
To continue is to have discussion that opposing counsel has refused to give a financing statement, has refused to give any record. This is to include their fiscal agent from Kelly Point and Gallagher, who also has stated that they don't have record in an email. So if their fiscal agent and their counsel for the fiscal agent states in an email to me that they do not have record, then where is the controversy? If Erie County DSS and Erie County Attorney's Office has also been asked for the same records, and refusal for those records, plus the refusal for records from this arbitral tribunal also have been denied in regards to specific performance and just contract and financial statement, because every contract will have a financial statement. And when it comes to notice of assignments, Jolene as an assignor, when she made application through Erie County DSS, that application provided her to be an assignor. And on all the other records that are on Erie County Clerk's website that deals specifically with adjudicative processes like we are speaking on now, specifically state Erie County DSS is assignor, and the mother is the assignee. And the records that have been placed in this tribunal also say the same thing. Not the most recent one, but all the ones that are prior to that. And when records are requested for financial statements, I don't expect to have a remittance payment schedule. I expect to have a full T ledger to include something that would be considered off-books bookkeeping, because Jolene can ask for a desk report which is much more representative of what a T ledger would be, but yet, if we were dealing with fair dealings, I would also be able to get a desk report to show all remittance payments and to whom and what parties are. And there's many remittance codes. There was actually 4 remittance codes that were on one ledger that I was able to obtain 2 years ago before Conduit State and Local Solutions, Erie County Department of Social Services, and this tribunal would not answer records. I have filed records in this tribunal last year, right about the same time, and Leanna Grasso had told me in a recorded telephone conversation that all of those records were sent to the 8th Judicial District for inspection by Mr. Carter. So there's...
Again, but did you inform Ms. Grasso that you were recording her telephone conversation?
It's a one-party state.
Sure, I'm just asking the question. Did you inform her?
It's a one-party state.
Is that your answer then? And let me ask you this then, sir. Are you recording these proceedings right now?
Of course, for fair dealings.
Okay, sir, that is a problem.
Why is that a problem, Your Honor?
This is a violation. You cannot be recording court proceedings. If you're in this courthouse, you would not be permitted to record these proceedings.
I'm not in the courthouse.
I know, but it's an extension of the courthouse.
How?
On the telephone, proceeding in court.
Well, we haven't established jurisdiction yet, Your Honor.
We're going to get there, sir. I'm trying to give you every opportunity, but I ask you please turn off any recording device.
Roger that. Will do.
You may continue, sir.
With the proceedings, all the information that has been requested from the opposing parties, particularly the moving parties. Jolene is the assignor. Erie County DSS is the assignee. And those records were then reassigned to Conduit State and Local Solutions. Those directly fall under 2 contracts for OCSE. Those contracts being, which are also forwarded to your court, and those are pretty lengthy documents which have been read in completion, which is Charlie 020543 and Charlie 021913. Those are the full contracts that were awarded from OTDA to Conduit State and Local Solutions to form the local operations of each of the counties for OCSE, which is now OCSS. Those detail specifically how payments are collected, how contracts and how enforcement actions are taken, and those are all dealing with admiralty time jurisdiction. This tribunal does not have admiralty time jurisdiction. You may have the right to contract, and that's what's happened, and I've asked for a specific contract that deals with compliance with both parties. When you have a third party such as Jolene that has complied with no actions, And on the original contract of the judgment of divorce, it has not maintained specific performance. Now we have an issue because this tribunal won't hear issues other than support matters, but yet you have contract violations that are preceding to that. I filed in Orleans County to have these matters heard, and it was refused, and a subpoena was refused. I also placed a subpoena on the record yesterday for records from the fiscal agent, meaning Conduit State and Local Solutions, which is the same exact office that opposing counsel works out of. And on the record, he's stating that he's there for Erie County Office of Child Support Enforcement as well. That's a conflict of interest because Erie County OCSE is a DBA of Conduit State and Local Solutions. So he's representing technically three parties right now in one matter. And that's a conflict of interest because one's a privately held corporation that has culpability for a commercial contract that they've accepted an accord and satisfaction to. And they've failed to report it to the principal, which is Erie County DSS.
Anything else, sir?
Why hasn't the court or Erie County DSS or Conduit State and Local Solutions provided any of the records that I've requested? This also includes New York State Unified Court System and OCSE or OCSA. If everybody states that no records exist, and I still haven't received a rebuttable presumption from Erie County Department of Social Services, still to this day. So there's procedural violations and a lack of procedural integrity that's happened from day one, dealing with notice of assignments, dealing with actually receiving notification of proceedings. And even for this proceeding, I would have never known that this proceeding was underway unless I had called, specifically called your office to find out. And it was only by accident that one of the clerks had told me that there was a case that was scheduled for today, a hearing scheduled for today. And that was by accident. So I would have never received it because proper notice wasn't sent to my mail receivership. It was sent to an old address.
Anything further, sir, on any of these matters?
Have you reviewed the evidence that I've placed before you on the record?
I've been reviewing this notice of bias and unfair dealings which you have directed the court's attention to. I have it in front of me, sir.
then this arbitrational tribunal can recognize the fact that UCC 3-311 accord and satisfaction and a letter of accord and satisfaction to include the U.S. Postal Code written both on the draft note and the letter have been received by Conduit State and Local Solutions on behalf of Erie County DSS, closing the matters of the account, terminating the account of Bravo Victor 15080 Golf 1, as it is attached to file number 197206.
Anything further, sir?
And as a notice of public notice has been placed in the paper evidencing that this accord and satisfaction has taken place. That has been given to all of the parties, to include Erie County DSS, OCSE, Conduit State and Local Solutions, New York State DTF, and there's been public recording of the UCC1, UCC1AD, and UCC5. Your office has been in receipt of that filing, that Erie County DCSS also has been in receipt of that filing, and so has Conduit State and Local Solutions 3 times.
Anything else, sir?
Yes, without a rebuttable presumption, the matters that are being brought from Erie County DSS and Jolene lack standing, because I was never given a rebuttable presumption, so therefore they do not have standing. Because procedure wasn't followed and a rebuttable presumption was not given in the first place. In the matters of New York State Law Enforcement Officers Union versus New York State, the court addressed the issue of an arbiter exceeding their authority. It is held that an arbiter award may be vacated if the arbiter's decision is irrational or clearly exceeds a specifically enumerated limitation on their power, which can be relevant in a case alleging unfair dealings. Mr. Weinsack, you have an oath of office, which is with the unified court systems, and you are a trustee, and you hold trust, public trust, jurisdiction has not been established, and a seat and venue has not been established. Proper notifications, lack of notice of assignment, failure to produce records to include financial statements and financial agreements have not been produced when asked. And these are very simple requests. And it is placed as a question to this tribunal why these records and why this evidence has not been produced.
Anything further, sir?
No, I've shown on the record that an accord and satisfaction has taken place per New York State UCC 3-311, and it has been accepted by the assigned party, Conduit State and Local Solutions. And the record that has been produced by Sarah Martina to this court also evidences on the 5/28/2024 that this accord and satisfaction paperwork has also shown up on their remittance payment schedule as further evidence that these matters are settled. By accord and satisfaction. Which has to deal with fair dealings and contract. And that is why New York State Department of Taxation and Finance does not have record of the account, nor do they report a record of the account existing in Erie County either.
Anything else, sir?
I'm waiting on a response from the court.
Sir, have you concluded your presentation on these pleadings?
I don't conclude anything. I can make a declarative statement that I am a man representing my estate, John Calvin Seth Lehman, and have handled the principles of equity to close the matters that deal with my estate. And these matters have been recognized by the state of New York, Department of Taxation and Finance, and the Office of State Comptroller. And also Erie County Comptroller as well confirmed that there's no notice of assignment, there's no filings, there's no information that has to deal with the county level.
Anything else, sir?
I'm waiting patiently for this arbitral tribunal to.
Okay. So then you've concluded your presentation for the moment then. Mr. Figliola, is there any response then from the county?
Yes, sir.
Go ahead.
This is not an arbitration. Court has jurisdiction under Article 6 of the state constitution. And then court, Article 4, powers court has
Objection, Your Honor.
to determine and grant any relief to the powers of the court.
Objection, Your Honor.
Sir, he's making an argument. What is the objection, sir?
Opposing counsel's stating the venue. He's giving the seat in the venue.
Sir, he's making an argument just like you made an argument. Everyone gets a chance to speak, and I don't believe he interrupted you. We're not taking testimony. This is oral argument on these motions. May continue, Mr. Figliola.
Judge, Mr. Lehman brought these issues up in 2020 regarding the modification of the judgment of divorce, arguing that this court had no jurisdiction. He filed objections, which was denied, never took alteration. The court does have jurisdiction to modify judgment of divorce unless the court remains. He's arguing contract that Lehman violated certain terms of the judgment of divorce, but that's separate and distinct from issues of child support. But it was a violation of some issues in the divorce decree because of the Supreme Court. CCE, unfortunately, does not apply in this case. There's a valid order of support for the remaining child who is under the age of 21. Claiming is not an minor, not denying the rights part of child support, not about or is able to do the support question. What was that support was available to support the parent, to do to support this child, what a
Anything further then, Mr. Figliola, from you? All right. Ms. Lehman, this is your opportunity to make any statements to the court regarding this. Is there anything you would like to tell the court? Just as you raise the volume of your voice so he can hear you. Go ahead.
I would also like to
I can't hear anything.
And please raise the volume of your voice. Just speak up.
health insurance and costs for our children, but I have a paper. Raise the age.
Anything else? All right. Mr. Lehman, this is your chance, your final chance for rebuttal. Is there anything you want to say in response to the comments made by Attorney Figliola or Ms. Lehman?
Yes, in response to Mr. Figliola, in the records that you've supplied to the court, Section 2, it says admiralty time law and maritime law are irrelevant to the issues of child support. This is incorrect. The records that have been supplied to this arbitral tribunal state that OTDA and Department of Taxation and Finance have a cooperative agreement along with all the subsequent counties, to implement SIMLA and FIMLA, and that has been supplied to this arbitration process. And this is an arbitration setting that's based off of the arbitration clause that's in the original contract, which is the judgment of divorce. So there might be concurrent jurisdictions, but this jurisdiction that is being applied in this situation falls in the federal realm in the way that it is being applied and not the state realm. So therefore, your claims and your positioning that this court, your terms, is what it is, you are trying to place the seat in the venue upon the court's record and speaking for the magistrate, and that needs to be noted. And as far as Forrest is concerned, he's not my child, he's my offspring. I don't have children, I have offspring. And as far as a suspense date of 21 years, that's a mortgaging finance statement. So if you're going to state that, then you need to give me a financing statement to back those claims, which your office has refused to do, which Conduit State Local Solutions, which is your fiscal agent, refuses to do. I can't even get a T-ledger from you guys, let alone accurate recordings of anything other than a remittance payment schedule, which doesn't fit GAAP or FASB principles. And at this time, do you want to offer a rebuttable presumption under 45 CFR? Or are you going to rest your case just with what you've stated, Mr. Figueroa?
Anything further, sir?
I'm waiting for counsel to give me an answer.
Sir, he doesn't have to give you an answer. This is your opportunity to make argument to the court. These are your pleadings. You can argue to the court. What the court and how the court decides is up to the court. But this is your chance,
Well,
sir.
take notice that I have asked and no response has been given. This is... Say again? I couldn't hear you.
Yes, so noted. You may continue.
What was noted?
That he did not provide an answer.
An answer to the... specifically dealing with jurisdiction financing statement.
That you asked Mr. Figliola. You said you wanted the court to take notice, and I took notice of that. You may continue, sir.
And as far as the assignor, assignee, records have already been placed into this tribunal that evidence that Jolene is the assignor and that they are the assignee. So that is also a moot point. Does the court recognize that as well?
Anything further, sir?
Does the court recognize that as well?
Recognize what, sir?
That on the paperwork that was submitted to the court, assignor and assignee is written on the paperwork that has been assigned, not the most recent, the ones to bring suit where it says assignor and assignee. Does the court...
Sir, do you have that court?
The court is the one that produced the record.
Okay, what record are you speaking of, sir? Please point it out to the court and I'll review the same.
Please provide me a moment. This record right here states, in matter of an Article 4 support 4D proceeding, Erie County Department of Social Services petitioner, on behalf of Jolene Lehman, assigner, petitioner, respondent, John Lehman. This is notice to appear in person. This was given to me by e-notify. It doesn't have a record name to it.
Sir, are you referencing a petition that's entitled Commissioner of Social Services Petitioner or Assigner on behalf of Jolene R. Lehman, Assigner against John Lehman, docket number F-03050-14/14A? Is this the document that you're referring to, sir?
Correct.
Okay, and then that resulted in the order modifying an order of support on consent dated March 31, 2014. Is that correct, sir?
No, this is different. This is recent. This is
Well, I have the petition
This
for modification of an order made by another court of this state. Is this the document that you're referring to?
no, that's the original moving document, Your Honor. This one, it was dated November 8th, 2024. And this was posted by Leanna Garasso, Deputy Chief Clerk.
Is that what you're referring to when you say the assigner and assignee?
This is in reference to that, but this deals specifically with contract law. And as an assignor and a petitioner, you can be a petitioner and also be an assignor. But if you assign,
So is this are you referencing the notice to appear dated November 8, 2024?
that's correct.
All right. I have in front of me. All right. And I will take notice of this notice to appear, sir, because it is a court document. I will take judicial notice of it. Anything then further, sir?
With this being stated with the assignor, Jolene assigned her rights over to Erie County DSS. For her to have a voice, I do not consent. If she needs to have a mouthpiece in the court, she can go and find counsel separate from Erie County DSS, because they're actually hearing matters from Conduit State and Local Solutions and Erie County Department of Social Services, a political subdivision of Erie County. Now, the matters of this Erie County Family Court, the IRS and the SEC, SAM.gov, all show that this court is not a political subdivision of New York. This is a for-profit corporation that has association with the Bar Association of Erie County, with a steering committee dealing specifically with matrimonial and family matters. Does the court take judicial notice of what I just stated?
Sir, that's your argument. Any other arguments, sir, you want to make?
Yes, I still have not been given a rebuttable presumption according to the record that you just stated that originally brought suit. To this day, I still have not been given a rebuttable presumption in which I can seek relief, which steers everything into the admiralty time and maritime jurisdiction and how it's been applied to this commercial contract.
All right. Anything further, sir?
This I would like you to take notice of UCC 3-311 and the draft note that was deposited along with the photographic evidence, along with the U.S. Postal Service process of service showing that there's a closure of this account.
All right, then. So hearing argument from all parties here, the court is prepared to make a ruling. But before I do, sir, I want to just cut to the bottom line of all this, which is, are you just simply asking the court to terminate your support obligation here?
A termination of the support obligation is what is requested.
All right. And, ma'am, do you agree to any of that? No. All right. You would agree that the second oldest child is now emancipated due to age, because he's now over 21. That is Lucas. Okay. But Forrest still resides with you, and you're still seeking child support for Forrest. Yeah. And I would note, Mr. Lehman, you have not filed a modification petition asking the court to consider modifying or changing or reducing your support obligation, because your support now is predicated on one child, that'd be Forrest, who's not yet achieved the age of 21 years or is otherwise emancipated pursuant to the terms of your property settlement agreement that was incorporated but not merged into the terms of your judgment of divorce. So, sir, I would suggest perhaps that you might want to consider that in the future. If you find that to be appropriate, you may file a modification petition with the court. Fourth floor in this building is where you can file such a modification. It's called the petition processing room. Or you may certainly file proceeding under the New York State Constitution, Family Court Act,